Good evening. Peter Davies is my name from Macquarie University. And today we've got the special privilege of having Professor Colin Reid give our next talk in our Law and Nature dialogue. But before we start, I'd like to acknowledge that at Macquarie University here, we're on the unceded land of the Darrigal clan of the Eora Nation. And we wish to pay our respects to elders past, present and future. Professor Reid is as I was saying, is our guest today, and Professor Reid has worked in Dundee University since 1991. He's written a number of key texts in the area of biodiversity law. Nature and Conservation Law is in its third edition. Privatisation of Biodiversity Law a couple of years ago. And soon to be released this year is Uncovering the Environment, and Colin might give a little advertorial for that publication as he goes on. Professor Reid's also been a patron of the United Kingdom Environmental Law Association, and has also advised various governments on biodiversity law. So without further ado, Colin, over to you.
Right. Good day, good afternoon, good morning to people here. Thank you very much for the invitation. It's a delight to be able to speak to you, especially some former colleagues here at Dundee. It's obviously a pity I can't be with you in person, but I think for all sorts of reasons, just traveling all the way to Australia for a single lecture might not be the best thing on environmental grounds. So the plan today is to talk briefly about how the law can move from the origins of wildlife protection towards a more holistic biodiversity law. And looking at experience in the United Kingdom, I try to identify a number of features which have become more prominent in the law that need to become even more prominent in the law if we're going to have a successful and effective looking after of nature. These features, I think, are fairly common to certainly the developed industrial world. And after that, I want to talk briefly about one feature which I think is definitely global, and then two that are perhaps more local to the UK, but have implications for other parts of the world. So we've been having some problems getting the slides to work properly, but I hope that when I click this, you'll see the features I'm planning to talk about. When you look at the history of the development of conservation law, I think a number of elements that have featured that need to feature more. That the law has become and needs to become more pervasive in what it's doing. It needs to take a positive rather than a reactive negative approach. Conservation needs to be prioritized. The law and the legal arrangements need to become more participative. They need to take a precautionary approach and to be proactive, particularly in our ever more rapidly changing world. And looking at the way the law has been going in recent decades, we're seeing a trend towards what you can call generally privatization. But there are also dangers for the things that are happening just now, with greater polarization and politicization of what's going on. So as you can see, there's an awful lot of P's there. So I thought about some photographs because it's early, late in the day. Rather than a plate of peas, which would be rather dull and boring, what I've done is, with the help of my wife, taken a variety of wildlife pictures from Scotland. And as you'll see, there is a certain pea consistency going throughout them in terms of the names and so on. To start off by looking at the need for the law to become pervasive. And for those of you who know Scotland, know me, you'd have known that the ptarmigan was going to appear there somewhere. So I put it in at the beginning, so you get that ptarmigan out of the way right at the start. So the law needs to become more pervasive. When you look at the history of conservation law, it started off as being very much restricted to particular species which were seen as being valuable or attractive, to particular sites that were seen as being of particular value, to controlling particular activities that were obviously damaging, obviously harmful. So hunting certain birds for their feathers was where conservation law in the UK really started. But as the law has developed, if it's going to take nature seriously, it has to become more pervasive. That means that in terms of species, it's not just the cuddly, attractive animals that get listed for protection. There's got to be an expansion to recognize the whole wealth, the whole variety of the ecosystem. So slowly the law has been extended so that listed species cover insects, reptiles, mosses, fish, and so on. Sometimes against considerable opposition. When snakes were first added to the protected species list in the UK half a century ago, there was a lot of to do in the press about why are we protecting these animals and so on. So you've got it, the law's got to become more pervasive in the species it protects. It also has to become more pervasive in the areas it protects. The conservation movement, conservation science, very much taking the ecosystem approach, that it doesn't actually work to protect isolated islands, citadels of conservation in an otherwise hostile landscape. They're not going to survive. Yes, special areas need special attention, but the whole landscape, the whole ecosystem needs to be looked at. Similarly, you have to tackle multiple causes of degradation, not just ban direct harm. It's not enough simply to stop the deliberate killing of animals. You've got to look after their habitat, make sure they can thrive and so on. And you extend that by involving concern for nature through environmental impact assessment before development goes ahead, through agricultural policy, incorporating some respect for nature. And in the UK context, this is shown by there being a biodiversity duty on all public authorities. They have to have regard to biodiversity in their activities, and a new proposal in England for biodiversity net gain. That is that all new developments giving planning permission have to show that in one way or another, they're actually producing a gain for biodiversity rather than damaging. So conservation has to be pervasive. It's got to extend beyond simply protecting a few special species, a few special sites. It also has to be positive. The law has to take a positive, but it's not enough simply to stop the most harmful activities. You've got to take a much more positive approach. And as I say, the law, if it's going to be effective, must do more than just prevent direct harm. And you see this in the language of the legislation. There's been this move from preservation to conservation, now talking about enhancement of nature. And that means that the habitat conservation rules have moved on. They moved on from simply stopping the most harmful activities to supporting enhancement, to encouraging the restoration of habitats. We've seen the reintroduction of extinct species, the sea eagle and the beaver, introduced in Scotland with great success. The beaver is a bit more mixed because, as well as the official test, there were some beavers that escaped in another much less suitable part of Scotland, and there are conflicts over the damage they can do to drainage and important agricultural land. But we're seeing, there's a general idea of reintroduction of extinct species. And governments talk nowadays a lot about nature recovery. A theme of current policy developments is meant to be nature recovery. How serious they are about that, no, but this idea that if you're going to have a healthy ecosystem, you don't just prevent direct harm, you've got to take positive steps to look after it, to manage it, to nurture it. Another requirement, another thing that's happened is prioritization. There's no point having lots of law trying to protect nature if it's not prioritized, if it doesn't have clout, if it doesn't feature strongly enough in policy making decisions in the way in which governments do things. So conservation is still rarely the overriding concern, but it is given greater prominence. And an important consideration of consequence of the biodiversity duty, the duty on all public authorities to have regard to nature, is it is always legally a relevant consideration that must be taken into account by public bodies. They can't ignore it altogether. They can't refuse to listen to people making conservation arguments. It is something that can be taken into account. It is something that can influence decisions. It may not always do so, but at least it gets there. It's one of the considerations that has to be weighed up. Whereas if you go back not that far, it could simply be set aside, ignored. No, that's not our duty. That's none of our business to deal with this. The priority is perhaps shown strongly in EU law. where the designation of protected sites has to be based solely on scientific criteria. To decide whether a site gets designated, you look only at the scientific criteria. What you do with the site may later on involve some balance with economic, social, other considerations, but nature comes first in terms of the designation process, rather than being set aside right at the beginning to give priority to economic and other considerations. And in terms of the legal controls on site, conservation has become a much more important consideration. So the original controls on protected sites were purely voluntary. You couldn't tell the landowner what to do. You were offering encouragements. You were trying to persuade them to do things. Now you do active landowner does actually need approval for many activities. Their interests as their rights as landowner have been given lower priority than the rights, the interests of nature. There's even a power to require action to be taken in certain circumstances. You can actually order people to do certain things. So although conservation may not have sufficient priority in society and in policy, it has become more prioritized. Conservation concerns can stop major projects. There are now substantial criminal penalties for people who break the law, but obviously there's still quite a way to go if we're really going to look after nature seriously. But greater priority has definitely been a trend in the evolution of the law. Another element, another trend is that the laws become more participative. More people are involved. And I should emphasize that these pictures are not to scale. We don't have tiny seals in Scotland and huge woodlice. Just happens to be the pictures that go together. A more participative law, that conservation shouldn't just be for the experts. Yes, we value our experts, Peter, we love our experts and so on, but they're not the only people who should have a say in this. And looking after habitat shouldn't just be a closed relationship between a statutory body, the conservation body, and the landholder, with nobody else having any say in it. And again, you see that in the law, this widening out of conservation, so that it's a concern, it's a matter of significance for a wider slew of society. So again, we've got this duty on all public authorities. You have rules on access to environmental information. So as opposed to anything that the conservation bodies do being a closed private matter that they can keep confidential, the Aarhus Convention, the rules on public access to environmental information mean that the public have the right to know certain information. They can either ask for it, or there's also an obligation to make material available. So you can find on the websites of the conservation bodies details of all the protected sites, what they're protected for, what the controls are, also rules on their relations, some of their dealings with the landowner, although the legitimate concerns about confidentiality, commercial confidentiality, and so on can also provide issues there. But the idea is that it's not just something that the experts of the statutory body deals on a closed relationship with landowners. It's much more public than that. And in Scotland, in particular, you've got a number of manifestations of this. The Scottish National Parks have directly elected members on their boards. Now, national parks in the UK are very different from national parks in most countries, because they're fully occupied. There's lots of commercial and ordinary activity going on within them, but they do still exist. They do have status. And I say a feature in Scotland is that some members of the board are directly elected too. Again, in Scotland, where you have proposed habitat designations, these have to be publicly advertised. When you're planning to designate new sites under the various nature conservation rules, these have to be publicly advertised. The public have an opportunity to make representations on the proposed designation. In terms of participation in legal action, conservation was the key concern that prompted a widening of the rules on legal standing in the courts. Until a couple of decades ago, access to the courts in Scotland was fairly limited. You had to have a very direct, your rights had to be more or less directly affected before you could take a case for judicial review. That meant that in relation to nature, that was often a problem, because nature doesn't have wild animals don't have rights, nobody has rights, and they're concerned. Sorting that problem was the key driver in prompting a widening of the rules of standing in the court so that environmental and other cases can come to the court. And a slightly different aspect of participation, but showing that this is making the law, making conservation a wider concern, is the introduction of vicarious liability for landholders in relation to some wildlife crime. There are concerns in parts of Scotland about persecution of wildlife to protect the hunting interests and so on. The law was changed so that the landholder can be vicariously liable for what staff on the estate on the land do. So they have to take, it's not enough just to have a one-liner in your instruction to staff and say, don't break any of the law. They've got to take real interest and concern in making sure that the staff, the contractors they get in, don't break the law. If they've done everything properly, fine, they can get away, but they've got to show that they've taken proper endeavours to make sure the law wasn't broken. So that's just an example of how you're trying to broaden out concern, broaden out interest, making sure that conservation is the concern of lots of people rather than simply the landholder or a private relationship with a statutory conservation body or the like. Law needs to become precautionary. We are living in an ever-changing world. We always have lived in an ever-changing world. One of the things that politicians and some people tend to forget, that the natural environment is always dynamic, always has changed. The fact that we don't have records of things that happened 300, 500, 3,000 years ago doesn't mean they didn't happen and won't happen again. So we need to, the law, if it's going to be successful, needs to develop and take on a more precautionary approach. And again, the EU has taken a lead in this. The EU court has taken a very strong precautionary approach in relation to aspects of conservation law, that projects on protected sites can be approved only if there's no scientific doubt that they can go ahead without adverse effects. One of the strongest manifestations of the precautionary approach, that you're only going to get, it's only lawful to grant permission for projects on protected sites if you can satisfy people that there's definitely not going to be any adverse effects. And again, a precautionary approach you're seeing in relation to the law in Scotland in the release of non-native species. So the rules that prohibit the release of species beyond their native range, and that applies even where the species is native in other parts of the country. So you can't release an animal on an island where it doesn't naturally occur, and applies even where species may be natural visitors to the country, occasional natural visitors to the country. Now, I know that scientifically there's all sorts of problems, particularly in Europe, where we're closer to other places than Australia, as to what is natural, what's the natural range, and so on. But again, it's taking this precautionary approach. We're going to be cautious. We're not going to allow an open book for people to spread species, to introduce new animals, plants in areas where they may have unknown consequences. So precautionary approach needs to be taken. And underlying a lot of this is the need for the law to be proactive. It's not enough simply to prevent things. You've got to be proactive. You've got to be looking forward. You've got to be trying to deal with the changing world. You've got to be making things happen rather than simply stand back reactively. So again, the controls on non-native species provide an example here. The ban is not just on the release of the species, but on their sale or on their keeping. So certain species that we don't want to have, the law prohibits you even keeping them in the country, even though they are properly protected, even though you're hoping they're not going to release. So again, you're being proactive. You're looking at the risks and trying to cut them out at an early stage. You have this idea of biodiversity net gain that's being proposed in England, that new developments will have to show that they're going to achieve a gain for biodiversity, both by mitigating the impacts on site, by providing habitat on site, or by making provision off site for various things. Huge issues of arguments about how effective that's going to be, what the capacity is to measure, to assess, to monitor this into the future. But it's an attempt, at least, to try to say that if we're going to have a healthy natural environment in the future, we need to do something now. It's not enough simply to stop us, to stop the direct harm we're doing. We've got to look ahead. We've got to try to deal with things. And there's increasing discussion of designations for protected habitat based on future needs. How do you respond to the challenge of climate change with sea levels rising? Protecting the current salt marsh at the coast doesn't do any good, because in N decades time it's going to be underwater. You need to make sure there's room for it to move inland as fast if it can, along with the rising tide. Animal species are going to have to go higher up the mountains, the hills, to get the appropriate climate. How can we provide sites for the future needs of the species? How can we provide ways for them to access those sites, and so on? The existing suite of protected sites in 150 years' time may be doing very little for the species that they're currently designed to protect. So a huge challenge there of how do we deal with this, but it shows that the law has to be proactive. We need to be thinking about this if we're going to have a healthy environment into the future. Those are features that I've identified by looking at the history of the law, the way it's developed, the needs of the law in the UK. The three other things I want to talk about. The first one is, I think, a fairly global trend, definitely. The other two may be more local, but perhaps have lessons for other places. So, privatisation, using privatisation as a fairly broad term to talk about a range of approaches to nature conservation. That the classic legal response in much of the world has been nature conservation is a matter of direct state regulation. The state, through whatever agency, designates sites, designates species. You then use the criminal law to say what you can and cannot do. You may use tax and other subsidies, benefits to assess people. But across the world, and Australia a leading example of this with its biodiversity banking and so on, biodiversity credits and so on, you're looking at an expansion of new ways that enable or require the private sector to take responsibility for nature. That it's not simply something for the government to do, it's something the private sector is enabled or required to take effect of. To look at, again, this idea of biodiversity net gain. You need to make sure that when you're developing land, you're not causing harm. Ideally, you're providing a gain to biodiversity. You achieve this by creating legal mechanisms for conservation covenants, conservation easements, where landowners agree and bind their successors. The important thing is that the future landowners are also bound that the land is going to be managed, looked after in a certain way into the future. And that goes against what has been centuries of policy in relation to land law to limit the extent to which land is burdened into the future. So you're now recognizing this is important enough to allow today's landowner to make terms that bind their successors. You have legal arrangements for offsetting, where damage in one place can be accepted if you're providing compensatory benefits elsewhere. Again, huge issues over valuation equivalence, all sorts of things. But as opposed to the nature simply being destroyed and nothing happening, maybe it has benefits. And as I say, you move on to the more sophisticated ideas of biodiversity banking and so on, which Australia has several good examples of. You have the idea that's been talked about for a long time, never actually getting through, of natural capital, that as well as producing their financial capital accounts, businesses, government should be producing natural capital accounts, showing how their activities are diminishing, enhancing, affecting the natural capital of the world. And throughout, and in various contexts, you've got the recognition of the value of ecosystem services, that undeveloped land that isn't producing a traditional commercial return isn't useless, isn't wasted. It's actually producing things of real value to society in terms of biodiversity, in terms of looking after water resources, in terms of aesthetic, leisure, and other activities. So there are various ways of trying to bring ecosystem services into the commercial world, showing their commercial value that allows them to be dealt with through private law mechanisms. The most obvious example perhaps is carbon credits, the idea that having a piece of land that's not necessarily producing commercial timber, but is growing trees that suck carbon out of the atmosphere is actually a valuable use of the land. It is producing something of value that should be paid for. But as this is a rapidly developing area, major concerns about this, concerns that in Scotland, agricultural land is being bought up for trees for carbon credits, and therefore pricing farmers out of the land with uncertain implications for agriculture into the future. So a huge area that needs to be thought about, needs to be worked through. Issue of ecosystem services also shown in the UK, particularly England, by agricultural support. The idea that when, in the same way as we have supported farmers for producing commercial goods, food essentially, if the support system should also recognize the other benefits they're producing and other sorts of public goods. And if I show the Section 1 of the Agriculture Act, you can see there a number of things that are now being accepted as products of agricultural land for which subsidies, financial support can be given. So the support isn't just for food and other production, for commercial production. The government support can be used in various ways for a whole list of activities, which are, you could loosely lump under the heading of providing ecosystem services. So public access, protecting the environment, improving the health of plants, conserving native species, looking after livestock, protecting and improving the quality of the soil. And a big issue coming into the future is going to be looking after soil quality, because after decades of highly intensive chemical-based agriculture, soil in many parts of the world is in a fairly dire state of health. So you've got this conservation law, wildlife law has these opportunities, is now seeing the value of ecosystem services. It can be brought into, incorporated in the law on many different ways. We're no longer stuck with a limited toolkit of direct regulation by the state. There are lots of opportunities to do different things. Then a couple of our final ideas, which may be a bit more another P parochial, but I think will have echoes in other parts of the world. And the first of these is polarization, issue over polarization. There are strongly contested views on countryside management, on what the countryside, even bits of urban land, are for. And one example of this is the rewilding debate. In areas of upland Scotland in particularly, they've been used for the past century either for grazing sheep or for grouse shooting and other hunting. Should we be trying to restore the natural variety of species, the natural vegetation and so on? Is this something hugely viable and ethical imperative on us to restore nature? Or is it in fact something that is destroying local society, destroying local culture? Is it a harmful activity? Is it something that's actually ethically wrong rather than ethically important? And how is this, what's the economic impact of this? How can you, it may be that if you've got one healthy, natural piece of land, it'll attract lots of tourists, but if all the land is like that, are the tourists going to come? What is the future economic, what's the economic future for the people living in the area? How do you make a transition towards away? So huge arguments about this with strong eyes, very strong views about what is ethically the right thing to do in terms of looking after nature, looking after the population and so on. And this crystallizes in the debate, the fierce, well, debate is a kind word for it, the fierce debate between the anti-hunting lobby and certain traditional country attitudes. In Scotland particularly, focused on grouse moors, areas of the upland that are managed to provide habitat for grouse that are then shot as both for as a leisure activity for the rich, but also a very valuable, because the rich are happy to pay for this. It's a good commercial use of the land as well. I was involved in a Scottish Government review of grouse moor management, so I was exposed to the strength of feeling on both sides of this argument and so on. Are these grouse moors artificial deserts where the natural vegetation, natural habitat has been destroyed, that are rife with criminal persecution as people try to exterminate the birds of prey and other things that cause any damage to the grouse? Or are they in fact a managed refuge for species squeezed out elsewhere, that because we've planted trees, we've had intensive agriculture everywhere else, they're the only place that certain birds can survive, and if the foxes, the crows and other predators weren't controlled, they wouldn't survive there either. So you've got huge arguments about this, focus particularly over the acceptability of predator control. Is it necessary and helping the species everybody wants to protect, or is it purely something that's done to protect the commercial interests? And on all of this, evidence is either lacking, it's contested, people will draw quite different lessons from the same piece of evidence. So we've got a huge polarization of views on what the country is for, what we should be doing with our landscapes, how we should be managing our land, what the future should be. And that ties in to issues of politicization. Because you've got these highly contested arguments, you've got inevitably these flow over, these affect the political world as well. So you've got the follow through from that sort of polarization. And then perhaps with particular urgency, emphasis in the UK, you've got the battles between, on the one hand, deregulation, and on the other hand, environmental concerns, which in the UK is particularly urgent because we're still clarifying the Brexit legacy, the legacy of leaving the European Union. Concerns over the recent trade deal signed with Australia because of how strong, weak the environmental obligations within that are. You've got the government, UK government at present, just saying opposite things all the time. On the one, you've got part of the government and the party that's all about deregulation. We need to free up industry from all sorts of red tape, all sorts of restrictions, and environmental conservation areas are absolutely in their targets. On the other hand, you've got the government committing itself to leaving the environment in a better condition than its predecessor, committing to long-term nature recovery, all sorts of strands. And there's a real issue about how these are going to fit together. And this then, to that, you've added to the wider issues of where tackling the climate and biodiversity crises, tackling those fits into national priorities, especially when we now have other pressures thrown at us by global events, economic circumstances, the pandemic, the war in the Ukraine, all sorts of things. The climate, if you hadn't had the pandemic, COP26 at Glasgow, the climate change issue would have had much more prominence. It would still be dominating the political agenda in a way that it doesn't because of all the other things. Short-term economic needs are going to come into it. So conservation law has had to develop, has to cope with this being a political issue as well. It used to be that passing conservation laws was just left to a few people who were interested and so on, because it wasn't really seen as having much importance. But because of the other changes, because it has to be more pervasive, because it has to be more positive, because it has to affect more people are participating in it, it becomes a political issue, which is great because it gives it more power, but also exposes it to these other concerns. So we're left with uncertainty about what the future would bring. That we've seen, I say, a number of features of elements that have grown, that have expanded as conservation law has become more important, more successful, but need to go further. Also some challenges to be followed. And continuing the theme of all the P's, I thought I'd just end with a pretty picture of what we see from one of the university buildings looking out over the River Tay. So thank you very much, and I'm happy to deal with any questions.
It's fantastic, Colin, and yeah, people can clap in the most polite Zoom way that we have available. So we've got the chat function if you'd like to have some questions, but I can see between claps and hand ups, Volker, you're doing a little bit of both, but I think your hand up was first if you have a question there.
I'll try just to remove the clapping hand. Not that easy in Zoom. However, it doesn't disturb, right? Yeah, thank you very much, Colin, for this very impressive talk. And my name is Volkov. I'm a professor at Macquarie University, and I'm working since almost 30 years now in conservation law. And I was also a coordinating lead author in the global assessment of IPBES for 1 year on this policy law issues, particularly. Yeah, one rather precise question and one more broader question and comment, actually. The precise question on this public advertisement of proposed habitat designation, is there also some preliminary protection involved? Because yes, that's often the issue. And the more broader issue is this biodiversity net gain issue, which also made it prominently in the EU biodiversity strategy and also is now in the post-2020 biodiversity framework draft of the United Nations, actually. Yeah, and I'm a big fan of that. I published already some things on it. The devil lays in the detail, of course. Yeah. And particular when it comes to the overall growth paradigm, economic growth paradigm, which we still have out there, when it comes to, for example, habitat types which need long-term development. Yeah, how can you develop them in offset schemes and so on? And particularly also the long-term implementation of such offsets. Yeah, usually the project is done, the offset is granted, but nobody looks on the offset, and the offset disappears slowly, yeah, or doesn't even get done, yeah. And so I'm, as I said, I'm a fan of this biodiversity net gain because it's a game changer, to my opinion. But how can we do this in the future differently and make it more stronger than we did it already in the past? Yeah. Thank you.
Yeah. Right. Thank you. On the first question, yes, they learnt at a very early stage that any notification of plans to protect the example, the worst example in England years and years ago was areas of meadow land. So you served on the landowner the notice that we were thinking about doing this, and when they visited next week, it had all been ploughed. So yes, as soon as the starting protection starts from the beginning, but can be removed if this doesn't meet the criteria. So yes, that is protected. In terms of yes, biodiversity net gain, offset habitat protection, it is a real concern that you are completely going against the grain of so much legal and state administrative regulation to try and put things in place for long times. Government departments have budgets. If they've got budgets for 2 or 3 years, they're doing well. So rather than trying to pay into the future, land law has been, been dead against enduring permanent restrictions. But some of the scientific evidence, that even after 150 years, habitats like wetland meadows that you think would be restored fairly quickly still don't have the full richness of species, microbial and other violent and unaffected areas, and it is a real problem. The law is trying to do that by allowing for covenants and so on. But in any event, I mean, anything you put in place in the law can be repealed in 20, 30 years' time. In any case, it's a question of trying to do the best, and I think importantly, trying to make sure that there's the capacity and the resources to keep it going, because monitoring this into the future, who's going to, you need to make sure there are good records. You need to make sure that there's an opportunity for the public, for pressure groups, other people to see what's happening and to apply pressure on it. And you need somehow to try to make sure that through reporting and other obligations, it's still on somebody's desk. I think reporting obligations are often, they don't seem to be achieving anything. But if you've got a clear reporting obligation, at least once every 5 years, somebody in the council, somebody in the official bodies got to look at the list and see what's happening. And if that is then public, other people can say, here, hold on, you're not doing your job. So it is very hard. I think openness and reporting is one of the ways of trying to keep the pressure on in relation to that.
Great, thanks, Colin. We've got a couple of questions from Kath Wallace here. I think the first one pivots around marine protected areas, which is, I guess, moving from the terrestrial to the water,
Yep.
and how some of those ideas might take place, particularly when you're looking at activities like seabed mining, etc. And then there's another part to a different question, which is the impact of the Aarhus Convention. But Kath, you might want to jump in on those.
Yep, on marine, I think that you have, in essence, the same problems, that you need to be trying to be positive, proactive, and make sure more people are involved and so on. The problem is the jurisdictional one. The problem is the one of controlling, the one of monitoring what's happening, that you need all the states involved to try and make sure that their ships aren't doing it. You need to try and have some sort of enforcement system. I think the essential issues are largely the same, but the physical, the practical challenges are different. Protecting nature is always difficult because a lot of the harmful stuff takes place way out, away from people, hidden in the countryside, and so on. At sea, it's even more. So you really need to try to work out practical ways, and that involves, I say, getting the states that are where the ships are based doing stuff, again, monitoring, reporting, and so on. But it's really hard to do that on the international level. In relation to the Aarhus Convention, yep, the UK is, and therefore all the bits of it, have signed up to the Aarhus Convention. Our law, the EU was also signed up and implemented more detailed rules to give effect to that. And those are still in place in the UK with currently no immediate plans to change them. So we have detailed rules that comply, that broadly comply with Aarhus. There are a number of areas where we're not fully compliant, but the basic idea that the public do have access to environmental information, they do have opportunities to participate in important decisions, they do have access to courts, although cost is a big issue. So we're broadly in line with that. And it did make a huge difference. The big difference in the UK came when the EU implemented measures on access to environmental information prior to the Aarhus Convention. And that really flipped things on its head, because environmental information was covered by the general rules on official secrecy. And all of a sudden you had to make this available. So you had public registers, access to all sorts of information made available. So the trend towards access to environmental information made a big difference, but it actually started before the Aarhus Convention was actually agreed.
Thank you. If I may just respond to that, that's very helpful. Kath Wallace, I'm actually in New Zealand. Just you're saying the issues are the same in the sea. I'm not sure I'm convinced by that, because the sea is, you know, common heritage or something.
Yeah.
And it's much less easily excludable for use for private purposes, but can be if people are vigilant. But a lot of the other ecosystem processes are so much more affected by many variables and not in any particular person's land, as it were. Maybe it's different. Maybe I don't understand the system. But
yeah, there are obvious differences. I'm not an expert on the marine side. You'll see a lot of my writing. I always try to remember to mention it, but usually to mention that there are some similarities, but also different challenges.
Thank you.
Yeah, good. Nengi, do you have a question? Then I want to come to a question from Rob Laird after that.
Yes, thank you, Peter. And so nice to see you, Colin, after all these years. And well, so nice to welcome back to our Law and Nature Dialogue series. So I was very curious about one slide when you mentioned about the polarization about the conservation law, and then it became politically sensitive. So to me, I think my question is, I mean, in the UK or Scottish context, how polarized does that look like? Because I mean, I'm thinking of something from a more kind of a biodiversity law perspective. I think one of the struggle or key issues for biodiversity law in many countries is the mainstreaming. So which means it's not actually mainstream into the decision-making and policy-making process in many countries. While now it has even become a polarized, politically contested issue. Does that mean that it's actually now is a very mainstream issue now in Scotland?
I wouldn't say mainstream because many people aren't involved, but you do have this. I mean, it's caught up with the whole animal rights movement and so on, which has on occasion led to violence in the UK. There have been animal rights terrorists doing stuff, and you have had incidents of gamekeepers and their families being threatened because they're thought to have been involved in persecution of wild birds and so on. But like equally, the protesters on one side saying that they get chased off the land, they're not entitled, they get deprived of their rights of access and so on. Other people saying that people are dumping corpses of birds and so on to try to put blame on landowners and so on. So for a number of people, it is a very intense issue. It therefore attracts an element of publicity and so on, which means that makes it hard for the government, because anything the government does will attract huge amounts of attention on social media from particular interests. And it's a fairly toxic area to get involved with. I feel lucky to have got out of the grouse review with as little damage as I did in terms of what we managed to do, because if you looked at some of the, well, basically none of us looked at social media while we were involved in it, because I suspect that people were saying nasty things about it.
Thanks, Colin. I think the next question from Rob, and I can see her up on the screen here, and it speaks to, I think, what I would loosely describe as trickle-down economics, where you've got the people at the top making decisions and how effective they are as you go down, particularly to local government. And having spent almost 20 years of my life there, I can deeply understand Rob's question. So, Rob, did you want to build on that at all before we pass to Colin?
Yeah, I suppose so. I just wanted to know how. It was interesting hearing how the broader EU and the like are sort of considering these policy issues with conservation law. But really, most of the conservation action happens at that local level, and it involves communities, certainly in Australia and around Sydney. And I was just wondering how well you thought, what the role local government was playing in the UK within sort of getting this message right, and how effectively that was sort of, whether there were any issues there or any challenges you thought between the message that the EU, that the state was having, that was trying to create, and actually getting that through at the enforcement level even, or even just within the people within local government and the people, making that happen.
I mean, local government plays a crucial role because most planning decisions and a lot of development is in the hands of local government. I think what we have in the UK is we've got a lot of quite strong voluntary action and community action in terms of conservation. And there's sometimes a challenge of trying to incorporate that into the more public, the more regulatory side of things. You need to try to capture the enthusiasm of people for it. So a lot of work goes on in schools, creating, eco-friendly areas in schools and so on. The problem seems to come, when people are teenagers and early careers, when the economic and other things take over. How do you keep that going? And trying to get people to understand the value of things which may not be the obviously attractive, pretty things and so on. I mean, SUDs, sustainable urban drainage systems, they need to be looked after. But I suspect that after a few years, people forget why they're there. They forget that that area of grassland with that dip is actually there for a value, trying to persuade people that flood management using perhaps long-term natural measures to slow down water getting into rivers and so on, that's as valuable and actually better than simply building a wall to stop your own house being flooded and so on. It is a constant challenge, and again with the mixed messages about what's really important for society, what we want to spend our money on.
Yeah, so I suppose the thing I'm wondering there is that community effort's all good and proper, but the scale of the problem is tends to be so large that we need, you know, things like floodplain management and redirecting takes a lot of money, right? And so you've got the large funding sources up at a higher levels of government. How effectively do they trickle down to actually get good results on the ground? You know, is the legal framework assisting with that, or is that, like when you talk about the politicisation of it, is that interfering with it in that regard?
I don't think it's interfering with it, but it's certainly, I mean, it's obvious that the law isn't working well enough. You know, clearly it's still causing harm, and there's a lot of talk about trying to shift the focus to outcomes rather than direct regulation, which in scientific terms obviously is great, but does open up all sorts of problems about how you measure the outcomes, when do you measure the outcomes, and so on. And is it simply is any recasting of the law at present simply a cloak for deregulation?